Now, what you're mentioning regarding that agreement, I really did not understand. I'm sure a lot of people did not either. So, but before that, I'm listening. You're saying that it's something, a document that they actually provided. The own bank had to provide someone that was represented.
There's a huge mystery with the loans, and all the parties that were involved in obtaining a mortgage after 2005. You just have to read. Just compare a document on a loan that your parents obtained at the time, like 30 years ago when they went about the house. Compare the package to the package that people sign after 2005. Exactly, exactly. And not only that, it's just the language that appears, for example, in a deed of trust. In a deed of trust, you have all these different people that have different functions on maintaining this loan and protecting the rights of the so-called lender. So all these different parties, you didn't have them before. And each one supposedly had an importance or something. But who really can foreclose on your house? Can all those people foreclose? The trustee, the beneficiary, the lender, it's like there's so many, the nominee. There's so many different people, and it's not like that.
How common is it to find things that they've actually done incorrectly or perhaps that are of benefit?
Very common. Very, very.
Can you give us some examples of,
very common. Very common.
What you've encountered?
For example, something that has happened quite a bit in foreclosures, but a lot of people have not been able to realize that. In the document, for example, in Virginia, they have to file this document that is called the Deed of Substitute Trustee. Okay? This is a document that is filed in the Land Records Division in the court, and is one of the first steps in Virginia to commence a foreclosure. This document substitutes the trustee, who is a representative of the lender, okay, in the original deed of trust. And this person has the power to represent the lender and come and say, I want to foreclose. Okay. What happens a lot of times is that the so-called lender doesn't have the loan anymore. So if you're the trustee for that lender at that moment, it doesn't matter because that lender doesn't have the loan. So you cannot just come now and simply file a deed of substitute trustee for the lender because it's not the same lender. Now it's a different lender. So they make the mistake of coming now and saying deed of substitute trustee, but the trustee that was originally, now it was of that lender, but now they have a different lender, which is not just even one party, is a network of investors. So all those things present different issues, and these documents that are recorded in the court have many mistakes.
So the wrong person is actually foreclosing the property?
Yes.
So it's basically illegal what they're doing.
I'm not going to say that it's illegal. I'm not going to come here in the air and say it's illegal what they're doing. Right. No, because it's a general statement. Of course, there's some foreclosures that have merit. And yes, perhaps the person is not paying for the house.
Because everybody knows that all these loans have been sold, 4 or 5 times is something common.
It's the process of securitizing the loan.
And not because it actually has different banks billing you, but sometimes the service was actually, by the same company, but it has been sold several times as well.
Exactly.
So that means that that's no longer, their loan. They don't have right, that particular bank, just to service it, not to foreclose.
Definitely.
So there's a lot of mistakes, I guess, with all these millions of properties going in. Because I see this as fairly new and everybody kind of learning, even the banks, because it's on their best interest for them to help and keep, somebody there. But what I'm thinking is, how can they handle all those calls? I mean, before, they would call them, I want a loan. Now, there's people looking for loans, and now hundreds of thousands of people calling in, save my home. What are the programs? And definitely, they're not prepared for that.
Some banks are helping quite a bit, but there's some banks that are not helping much. Simply, maybe they don't have the means, the personnel, the infrastructure to be able to help. Or maybe they simply don't have the money because they're paying their CEOs way too much money. It could be many reasons, but we're able to obtain quite a bit of modifications, very nice modifications for some people, without a doubt, definitely. And if we cannot obtain the modification through just the normal means of going through a modification process and presenting the right documents, then we can persuade them with an audit or maybe a lawsuit, or maybe we can simply talk about bankruptcy chapter 13.